I guess the first thing to say is that mediation is now a very well-known, sophisticated process, isn't it? So gone are the days when it was the Wild West, so to speak, gone are the days when it was a new thing coming in. So people are now very tuned in to how best to prepare for mediation and how best, from the client's perspective, and therefore the lawyer acting for the client, you will get the best result. So the sophistication is important, the preparation, the thinking through of how you're going to play that day, how the client is going to interact with you as the advisor during the course of that day, and what good looks like. And actually, rather more importantly, from a mediator's perspective, what acceptable looks like, because it's seldom that you get out of a mediation acting for a client in mediation where you say, that was a great victory. The point is, it's a victory of common sense, but it's not necessarily a victory for the parties, although in a week's time, in a month's time, one hopes as a mediator that people look back on that and say that was exactly the right decision to take. Yeah, I'm a firm believer in not having formulaic mediations, and that was the formula of mediation started really with training, didn't it, way back when, 15 years ago, 20 years ago probably. You know, we'll have the opening session, we'll have one party saying this, we'll have another party saying that, we'll have the case summaries ahead of time, the position statements, and then we'll run it during the course of the day with the mediator shuttling back and forth. Now mediations obviously do adopt that process, but I'm a sort of mediator that says, and I was in practice acting for parties in mediations, where it says, come on, let's see how we can shake this up, how we can actually make progress without having necessarily to go through the steps in the dance. Some of those steps are really important. So in my view, the opening meeting between the parties is important, although I am finding in practice that there are more and more cases where parties don't want to meet, actually, and that's a challenge for the mediator right at the start, because the psychology is not good at that stage, obviously. So let's try and not just be guided by formula because the training materials say this is how you do it, and therefore the lawyers say this is how we expect it to be done. Let's see whether there's some innovative way of perhaps putting the principals together early on, perhaps putting the lawyers together early on, whatever it may be, and have flexibility. Yeah, can we split it into two questions therefore? So ahead of time is really, really important. I'm a great believer in the preparation process, whether I'm acting for parties or as a mediator. And preparation is not just, hey, I've got a mediation in 10 days' time, I'm doing the position statement, I'll get the clients in, etc., etc. It's a bit further than that. It's the real thought process about what am I going to achieve, what is the client's aims and objectives going to be coming out of this? Have I educated the client properly on how mediation works? You know, some clients, particularly insurer clients, are very sophisticated users of the mediation process. Other clients find the whole thing an arcane process, and particularly some international clients, actually. So flexing how you prepare because that's what your client needs the help on is really important, and that's ahead of time. And also creating a situation where there are no surprises for the client. I think from a mediator's perspective, if a lay client is being surprised during the course of the day about how the process is working, where's the mediator now, you know, has he just gone off for a sandwich somewhere? Well, the answer is no, he hasn't. He's working hard in the corridor. If the whole thing is a surprise and a sort of mysterious art, then I don't think the prep has been done as well as it might have been, actually. And the psychology, doesn't mind about that. I don't mind about that. But the psychology is quite important to bear in mind, really. If a client's feeling uncomfortable, if a client is feeling, God forbid, in any way rolled into a process that leads to a result that he or she the following morning regrets, then that's a really poor mediation. And that's a poor mediator, actually, but it's also, I would suggest, poor prep as well. So that prep, before you get there, is really important. The case summary and what you say and how you say it, and the effect it has on your opponent, and in particular his or her client, is really important. that'll be a moment when, perhaps for the first time, depending on whether we've got pleadings, etc., so 60 pages of pleadings may be summarised into 5 or 6 pages of case summary. And that will go to the other side's client almost inevitably. And that's an opportunity to make an impression. It's an opportunity to make an impression sometimes about, beating chests and I'm going to see you in court and, this is a one-off opportunity to do a really good deal from my client's perspective and if not, we're in the Court of Appeal tomorrow. But it's also an opportunity to make an impression about, we're here to try and sort this out. People use the words, we have a really strong case and we're committed, however, to the process to see if we can achieve things reflecting the strong case we have. And as a mediator, you get slightly used to that sort of terminology, if I could put it that way, and as a party to mediations as well, actually. So it's a question, in summary, of getting these things out into the open in that sense, albeit in a without prejudice context, obviously, and decide how that's going to play both with your client and with your opponent, and make use of the first opportunity you might have had actually to make an impression with your opponent. Well, again, that's a really important question, it seems to me. So I think the mediation starts when you select your mediator. So there'll be mediators you worked a lot with, there'll be mediators who are new to you, there'll be a mediator suggested by your opponent that you automatically think, whoa, is that the right person to have here? I think that selection process, rather than who's available, who can do it, clearly if it's an emergency, really quick fire mediation, then you have to regard that as that's the way it is. But if you've got a process that says, I think this case is suitable for mediator X, then that's when the mediation should start, really. So when mediator X picks the phone up to speak to the parties ahead of time, having probably at that stage had the case summaries through, then that's a process where you, the individual lawyer, are talking to the mediator, usually without your client on the call, in the room, whatever the phrase may be. And that's an opportunity to really sort of decide how you're going to play that with the mediator. I always say as a mediator that the mediation starts at the time of that first conversation. So the protections around it, the confidentiality, the without prejudice privilege starts at that stage, and I make that very clear. And that's designed to help the lawyer who may or may not have worked with you in the past to actually start to develop that confidence and credibility in the process and in you as the mediator in charge of the process, to actually start saying what he really thinks about the case. Now, that's a slightly naive comment because I don't think lawyers ever tell you, in that first conversation at least, what they really think about the case. But if there are aims and objectives that won't have come out from the pleadings, that won't have come out from case summaries, but the client is motivated by those aims and objectives, it's really, really important for the mediator to know that early on, because he's not going to be saying anything in the other room about that, but he's on the top of the wall between the parties, and to be able to do the best job, he needs the best information. And so I always do encourage people, with varying degrees of success, I have to say, as a mediator, I always do encourage people to say, just tell me. Your client isn't in the room, you have the opportunity to talk one professional to another. I'm not suggesting for a moment you breach anything other than the professional solicitor-client relationship, but give me a feel for what's really motivating people here to go no further between the mediator and the party. And that, I think, helps the process. It saves a bit of time on the day, and it, most importantly, in my view, starts this credibility building, trust building that must exist between a mediator and the solicitor or counsel and, of course, the lay client. And it's a bit like speed dating, isn't it? Because you have a really limited window to gain that confidence if you're going to do a good job on the day. I think you really have to be very flexible. I think if you have a rule that, I am the great I am and I'm coming here and telling people how this operates, that could be exactly the wrong thing to say, because mediation, as we all know, is owned by the parties, not the mediator. You're there trying to hold coats, you're there trying to create a process that has credibility from both their perspectives, or all of their perspectives in a multi-party case. And so if you're coming across as, here are the directions for the day, then I think you're a poor mediator. Equally, there's got to be some structure, particularly I would suggest at the start of the day, where people are starting to feel less uncomfortable about the process and starting to feel this is actually making progress. So I think the formality, if there is formality, is really at the start of the day, and then that dissipates over time, and then you've got to be in a situation where you might be putting the principals together in one room with you, you might be putting the lawyers together in one room with you, you might be walking around the churchyard, whatever it may be. You've got to have that flexibility, but you've got to earn it, it seems to me, as the mediator, by having a process that people can establish confidence in at the start.
Are you helping coach parties through how they present offers, think through what they want to say to the other side?
Yeah, I think within limits, you've got to preserve your independence, clearly. But a key benefit of mediation, in my view, when you're in that private session with the party who is perhaps making the first offer, the opening offer, is to encourage them to use you as a sounding board, to use you as the phrase I always use is test drive this with me. Because as soon as I walk out, I'm your servant at the end of the day. If you tell me you want to make that offer, then I'll go and make that offer. If you tell me you want it couched in the following way and to explain how it's made up, then I shall do exactly that. But I do have, that's a privilege. I do have the right, which that privilege gives me, I think, to say, before I go out of your room into the other room to make the offer, how do you think that's going to go down in the other room? Do you really feel this is a way to achieve momentum, to get to pace, to get to a solution? Do you think it might be counterproductive? And I think a mediator is entitled to do that. And if you've established credibility and confidence in the parties, then they'll listen to you. And that has regularly happened to me in practice, where people have said, yeah, actually that's a good point, Andrew. We hadn't thought about that. We hadn't thought how that might play in that particular area in the other room. So we're going to have another think about that. So stay with us while we have a think, or come back in 5 minutes and we'll tell you where our thinking has got to. And that's a privilege, actually, to be able to sift and focus people before they cross a particular bridge in making the first offer. Well, first of all, is to use it. Sometimes you get the feeling that solicitors or counsel or whoever it is, representatives generally, are thinking, right, I'll go and have a cup of tea now, or whatever it may be. And I don't diss that, obviously. But a good mediator will be saying, I'm now going into the other room. I think that may take me half an hour, 3/4 of an hour. Try and manage expectations, because it's really, it can be a real challenge if people are saying, well, where's the mediator? We haven't seen him for an hour. So I have a real rule that I keep people informed about timetables and likely timetables. And then when you're leaving the room as a mediator, it's a great thing usually, and it helps as the process goes on, to ask the parties to think about a particular point or points. If you've got authority to say in one room what the other side has said to you in another room on a topic, put that to them, give them an opportunity to think about that, take advice without you there, and focus some efforts while you're away in the other room. And I would encourage, from a lawyer's perspective, and this is a lawyer's masterclass, I would absolutely encourage that time to be used as much as you can, because it's a good time to reflect, how's the progress going? How is our progress in this room working as compared to the plan we had when we first arrived today? and how are we going to move it on? How's the pace going? Are we feeling it's the right pace? Are we feeling we need to up the pace because it's now getting, 6 o'clock in the evening, and are we really going to be here at 2 o'clock the following morning? All those sort of important questions, and make use of that time. What they don't need to be doing, if I could start with that, is to say, well, there you go, we tried that, it didn't work. We've got a directions hearing, a PTR, whatever it may be, coming up in 3 months' time, 2 weeks' time, whatever it may be, so we'll just prepare for that. I think having invested the time, the emotional energy, and a certain amount of cost, at least, in getting to a mediation process, and I speak as a mediator as well as someone representing people in mediations, you come out of a mediation that hasn't worked or hasn't achieved a settlement, let's put it that way, feeling inevitably a bit flat, actually, and that's the professionals. So imagine the lay client, they feel flat. They feel, why did we just spend 8 hours of our lives trying to achieve that? Yes, we made some progress, but I've still got this case around my neck. I've still got this expenditure, I've still got my chairman talking to me about why are we still in litigation, whatever it may be. And so use that psychology of the flatness to then say, well, how are we going to make some progress here? Statistically, as CEDR will know, as I know, mediations that don't settle on the day, a good proportion do settle in the week or 10 days afterwards. How can a mediator help that process? Well, the answer is, I regularly don't achieve, sorry, what's the phrase, how many negatives here? I regularly do achieve settlements of mediations, so I don't specialise in not achieving settlements of mediation, but on occasion that doesn't happen, and it's important that you continue to be invested in the process as a mediator, and therefore encourage the parties to do so as well. And how best to do that? In my view, it is to keep the mediation process open for a 7-day period to 5 o'clock on whichever day, or a 10-day period, so that nobody's worrying about, well, if I pick the phone up, is that still protected by, the without prejudice privilege, whatever it may be. And also create a timetable whereby you as the mediator are going to phone the parties and say, you've had a few days to think about this, your client has as well, how can I help further? And that tries to head off at the pass the inevitable human question about, well, why should I pick the phone up first? The answer is you're not picking the phone up first, it's the mediator who's picking the phone up first, and he's already alerted you and your opponent to the fact that that's going to happen. And that then leads one of two ways. It either leads to, yeah, well, we're going off to court now, so thanks very much, Andrew, goodbye. Or it quite regularly leads to, yeah, I'm really pleased you called because we've had this post-mortem, we want to do something, we were thinking about doing something, can I test drive that with you? And then you are again in that privileged position on top of the wall between the parties, and you can see and hear what they're saying, and they can't see and hear what each other is saying. And you need to try and use that privilege and not give up, actually. It's really important. People have invested time, emotion, energy, money into a process that obviously I absolutely believe in as a litigator as well as a mediator.